My name is Shawna Ramsay, and I am a consultant with TitlePLUS Title Insurance. I want to thank you for coming out today, and thank you for those of you who have logged in online as well. I'm going to speak to you today about property ownership and access issues. I found a quote that I thought was interesting for today's topic. Life, liberty, and property do not exist because men have made laws. On the contrary, it was the fact that life, liberty, and property existed beforehand that caused man to make laws in the first place. So we're going to start with unopened road allowances. Crown road allowances were originally laid out in the 1800s in a grid pattern, and they are 66 feet wide and can be found either running in between lots and concessions or running along the edge of many lakes and rivers. As time went on, some of these road allowances became used as concession roads or municipal roads, while others remain unopened since they were often laid out in locations that are not suitable for the construction of roads. In 1913, all original Crown road allowances were vested to the municipalities by virtue of the Municipal Act, which means that the municipalities have the right to exercise control over their development. These unopened road allowances are not established, assumed, or open roads, but rather private municipal property that has not been designated for public use. For the most part, the municipality will allow the general public to use these road allowances. However, they do not permit the public to improve them in any way. Land surveys and property lines were originally measured and established using chains and links. The first chain, known as Gunter's chain, was invented early in the 17th century. It was exactly 66 feet long and consisted of 100 links. The chain had 198 points of friction, and as those points were subjected to wear and tear, the length of the chain changed. It also contracted slightly in colder temperatures and expanded in warmer ones. Eventually, a metal tape chain became a more popular method of land measurement, followed by various other methods such as the theodolite, the tellurometer, and the total station. It wasn't until later in the 20th century that methods of land measurement were digitized and became more accurate. Combine these older, less efficient methods of land measurement with the fact that prior to 1992, when the Ontario Building Code came into effect, many smaller rural communities didn't perform building inspections or verify property boundaries, and you have a recipe for lots of potential discrepancies in property ownership. For instance, while doing some research on this topic, I came across one particular scenario where a couple purchased a house that was built prior to the Ontario Building Code coming into effect, and it encroached on 21 feet of road allowance. At the time of the purchase, the couple was made aware of the encroachments, but their thoughts were mainly focused around the fact that if the house burnt down, they would not be able to rebuild on the same footings. They did not, however, really consider how future purchasers might feel about the encroachment. Many years later, the husband passed away, and the surviving owner decided that she would like to sell. Unfortunately, when she attempted to sell the property, any potential purchasers were walking away from the deal as soon as they found out about the encroachment. The owner has appealed to City Council, hoping that she might be able to negotiate an encroachment agreement, sell the property to the municipality, or even purchase that 21-foot section of road allowance. Unfortunately, the municipality has taken the position that they must protect their taxpayers, which means that they are unwilling to accommodate the owner just in case they need to open the road allowance at some point in the future. This is a reminder of how important it is to consider all of the possible complications when your clients agree to accept a defect such as this one. If handling the purchase of such a property, it is important to remember and apply the Law Society of Ontario Rules of Professional Conduct. I bring your attention to Rule 3.1-1. In this rule, competent lawyer means a lawyer who has and applies relevant knowledge, skills, and attributes in a manner appropriate to each matter undertaken on behalf of a client. Various skills and attributes are outlined in subsections A through K, which are included in my paper. It may not always be easy to ascertain the geographic fabric of the property, but a good place to start is always with the title search. With the home discussed earlier, which was built on a section of road allowance, the property consists of 2 separate pins. One of those pins is perfectly fine with no sign of any defect or title problem. The other pin remains in the registry system. This portion of land is legally described as part of a street on a plan and shows the surviving widow as the registered owner. Further investigation, however, reveals that it is in fact unopened road allowance and was never conveyed by the municipality, nor does any encroachment agreement exist. If a pin is left in the registry system, there is always a reason for the non-conversion, and further investigation is normally necessary. Upon viewing the pin map for that second registry pin, you can see that a large portion of the home was built on that portion of land which was not converted. In addition to reviewing the title search, Google Maps satellite images are also very helpful in trying to determine if there is a road allowance crossing the property. The property in question is shown on the map at the end of the yellow line, and as you can see from this satellite image, the street could be extended. However, it would run right through the house. The options available to resolve this issue are limited to either obtaining an encroachment agreement from the municipality or purchasing the portion of unopened road allowance that the house encroaches on. If after communicating all of the risks and available options to a prospective purchaser, they ultimately decide to go ahead with the transaction nonetheless, it is always a good idea to get them to sign an acknowledgement indicating that you have explained everything to them and outlining the risks. Keeping in mind that an unopened road allowance is still owned by the municipality, there is always the possibility that it is being used for a different purpose. For instance, snowmobile associations and ATV groups often gain consent from the municipality to include road allowances in their trail systems. It may surprise a new property owner to find out that in the wintertime, snowmobiles are driving either right through or perhaps right beside their property, and they may not be pleased to hear this noise at midnight. An inquiry with the local municipality can confirm if any consents have already been given. A little bit of additional investigation can also provide a heads up if arrangements are in the works for future trail additions. This exact situation was of some concern for property owners in an area which is well known for being snowmobile country. The area's snowmobile club requested the use of a road allowance to add to one of their existing routes. A couple of years prior to this request, City Council had agreed to grant the club access to the south side of this very same road allowance and therefore considered this to be an extension of the existing route. The snowmobile club only required 15 feet of the 66-foot road allowance and assured both the council committee as well as the area residents that they would make every effort to position the trail in such a way as to have the least impact on the surrounding environment. One of the homeowners, whose property was bisected by the road allowance, expressed concerns about the environmental impacts and possible erosion that could be caused by the removal of trees. Other homeowners also addressed the committee since the road allowance ran between their 2 homes. They were concerned about the noise that would be caused by the snowmobiles, especially because the trail, as it was proposed, would allow snowmobiles to travel about 50 feet from one of the homeowners' bedroom windows. This is a perfect example of how, although homeowners are often consulted, ultimately it is the municipality that will determine how road allowances will be developed and used. This could very well impact the resale value of those houses that are affected. When you become aware of such an issue that will likely impact the use and enjoyment of a property, even though the road allowance may not actually form part of the property in question, it is important to advise the purchaser of the potential ramifications. Rule 3.2-2 states that when advising clients, a lawyer shall be honest and candid. Subrule 1.1 continues to define that the duty of candor requires a lawyer to inform the client of information known to the lawyer that may affect the interests of the client in the matter. Subrule 2 indicates that the lawyer must give the client a competent opinion based on a sufficient knowledge of the relevant facts. Buying an unopened road allowance may be possible whether you are dealing with a road allowance that runs through lots and concessions or whether it is a shoreline road allowance. Provided there are no plans for future development of a roadway or any environmental protection concerns, especially since the sale of unopened road allowances is a source of income for municipalities. When shoreline road allowances are purchased, there is normally a deposit provided, which includes a non-refundable administration fee, as well as partial payment for a specific length of the road allowance. Any portion of road allowance above and beyond the set length would come at an additional cost. After doing some research, I found that just like many businesses, from time to time, municipalities will do some investigating to determine if their processes and fees are in line with other municipalities. If a municipality has been following the same fee schedule for a lengthy period of time, there can be an exorbitant increase in costs. These costs are justified by municipalities based on the fact that the sale of unopened shoreline road allowances is an exhaustible income. In addition, as the value of waterfront property goes up, so does the value of these road allowances. In some municipalities, there are many unopened shoreline road allowances, and there is no intention of opening them up simply because of the fact that certain areas are built on the Canadian Shield, which makes it impractical, if not impossible, to build roads around many of the lakes and rivers. Another interesting factor for consideration is that waterfront lots are assessed for tax purposes as being higher value properties. Technically, where an unopened shoreline road allowance lies in between a property and a lake or a river, those properties are not actually waterfront properties, since they do not have legal access to the water. This could really throw a wrench in the amount of taxes that has already been paid in property taxes for those that technically did not actually have water access. It is also possible to find unopened road allowances that perpendicularly abut a body of water. These are often used as water accesses for pedestrians and even possibly for those wishing to launch a boat. If a client is purchasing waterfront property, these types of road allowances should be considered a red flag, as they may have a serious impact on the use and enjoyment of the property. Another point to consider here is the fact that there is no longer any requirement under the Municipal Act to offer these road allowances to the abutting waterfront property owner. If an owner of the property that does not have water access abuts any part of that road allowance, they can apply to the municipality to purchase it. Rule 3.2-1 of the Law Society of Ontario Rules of Professional Conduct states that a lawyer has a duty to provide courteous, thorough, and prompt service to clients. The quality of service required of a lawyer is service that is competent, timely, conscientious, diligent, efficient, and civil. This rule ties in with being knowledgeable about various property ownership and access issues. There is additional information provided in subsections 1, 2, and 6, which are provided in the paper. Another possibility is where access to a property being purchased includes a portion of road allowance. In this scenario, it needs to be determined whether the road allowance has been opened or not. If the section of unopened road allowance is not passable by vehicle, then it will be necessary to seek consent from the municipality in order to make any improvements or alterations to the road allowance. In Goudreau versus Chandos, Mr. and Mrs. Goudreau had to traverse a portion of unopened road allowance in order to gain access from their property to a municipal road. They requested permission from the township to cut down certain trees and grade a portion of the unopened road allowance in order to make that road allowance passable by vehicle. The township responded by indicating that consent would be granted, provided that the Goudreaus constructed the entire road to the standards of the Ministry of Transportation. Justice Weeks held that a member of the public who is required to use an unopened road allowance for access to their property does not have the right to cut down trees, remove or grade other natural obstructions, as may be reasonably necessary to permit the safe passage of a motor vehicle without the express permission of the municipality. The courts have recognized and accepted that unopened road allowances may be used by the general public for access to or egress from adjacent lands. However, they also take the position that unopened road allowances may only be used as they are found. When unopened road allowances form part of the property's access, it's important to ask about the physical characteristics of the land. The seller may have been gaining access by use of an ATV or some other means of transportation which is not feasible for your clients. In any event, once again, it would be prudent to explain the potential complications and to have your clients sign an appropriate acknowledgement. Okay, so moving on to additional types of roads. I'd like to start with forest roads. Since original road allowances were laid out in a grid format, they were often not located in locations that were convenient for cottage owners and other country property owners. As a result, trespass roads, or more commonly referred to as forest roads, were created either by the first cottage settlers in an area, or they were constructed by the municipality on privately owned land without being expropriated or obtaining deeds to the land. This process is, of course, where the name forest road came from. In virtually all cases, these roads were constructed prior to January 1st of 2003 and were therefore assumed or opened through the expenditure of public funds or through statute labor. Statute labor means that the municipality completed sufficient work on the road to qualify it as a municipal road. These roads may have been constructed to municipal standards and are either maintained year-round or perhaps just seasonally. The general public use these roads under the assumption that they are municipal roads, and for jurisdictional purposes they are. There are only two differences between forest roads and municipal roads. The first one being that the fee in a forest road is owned by a private party. The second one being that a forest road width may only be 40 or 50 feet, as opposed to a municipal road which is generally 66 feet wide. The law is clear on the fact that the municipality is liable for any accidents that occur on forest roads, since they are de facto municipal roads. For this reason, municipalities rarely go through the trouble of expropriating properties or obtaining the fee from individual property owners. Following the passage of the Public Lands Act in 1853, colonization roads were built to give settlers access to free plots of land. The settlers themselves built the roads with money that was given to them by the Crown. The Legislative Assembly of the province hoped that the new settlement opportunities would stop emigration to the United States. There has been much controversy over the construction of these roads, since some of them cut right through Indigenous lands. One particular road, named Colonization Road, which is located in Kenora, Ontario, has sparked some media attention.
To me, as long as Colonization Road exists, metaphorically or literally, that's a real roadblock for me. Born and raised in Fort Frances, spent a lot of time on Couchiching on my reserve, drove past that road, on that road, around that road, swam off of that road into the lake. We don't even consider what that street sign might mean.
The government decided if we create a road system, then they will give the access to the land and we would be able to have a greater population.
But in doing so, displaced many Indigenous peoples that were already here.
The situation at Shoal Lake 40 was that we're going to colonize the West. They just rolled in the bulldozers. In the end, they got 3,500 acres of land. They displaced the community. They built a diversion canal that cut that community off from the mainland, so they no longer had access.
In that house fire, we didn't have the infrastructure or the service to help save my mother, my sister.
In small towns, the big murals on the side of the banks tell the history of the settlers often. Are you worried about the way we've sort of been erased?
The invisibility of Native peoples allows racism and stereotypes to continue to perpetuate, that Native people are, don't exist anymore.
This is still our traditional land.
Right.
And it's important that people realize that.
By order of Parliament, land grants are to be given for the purpose of settlement by order of the Public Lands Act.
What you're looking at is an offer of irrigated land, access to trade markets, roads, things like that.
These settlers, they really were, consciously or not, the vanguard of British civilization. Their names are on our streets. I mean, we revere and honor these people for their hardships.
What is the challenge that I could offer to Canadians? What could I say to them to get them to understand that A, better relationship is possible, B, we need you to be a part of that process to ensure that that relationship happens, and C, how do we give Canadians the ball, so to speak?
Today, as you've seen, some of these roads still exist and have been opened or assumed by municipalities and are used as municipal roads. Others are no longer used and remain passable only by ATVs or snowmobiles. Crown patents were issued to individuals, often without any reservation for areas that had colonization roads running through them, and where the municipality has not assumed the road, they remain privately owned. Purchasers of property with a colonization road running through it should be aware that the road may still be subject to the rights of the public to use it. There is often no sign on the pin that the property is subject to any colonization road, and they are often not shown on any land surveys. Be aware that these roads can cause all kinds of problems for property owners, ranging from damage to the property itself caused by ATVs and snowmobiles to liability issues. This is still made abundantly clear today with disputes that continue to arise. I came across a news story about a couple who own property that has a former colonization road running through it. At one point, many years ago, the road was passable by vehicle. However, now only ATVs are able to navigate the trail. The owners of the property decided to put up signage informing people that the trail will be closing and that anyone using the trail is trespassing on private property. They decided to stop others from using the trail because of the damage that was being done. The owners have done their own investigating, including looking at archives and municipal records, and have also concluded that there is nothing on title to the property indicating that there is any sort of right-of-way or easement, nor any reference to a colonization road or a public trail. One particular individual has been using the trail for both commercial and personal ATV purposes. He provided copies of maps up until 1972 showing the road, and also provided a letter from settlers in 1881 to the Commissioner of Crown Lands asking for money to complete the road. Both parties have retained land surveyors, and both arguments are supported. I did not find any resolution to this issue other than City Council had decided to discuss the issue again at their next Council Committee meeting. Moving on to rights of ways. When dealing with access by way of a registered right-of-way or easement over private land, you may encounter a few complications. For instance, there may be a together with on the dominant lands, however the servient lands may only reflect a subject to in favor of other parties and not specifically in favor of your client's property. In this case, your clients would not have fully registered protected access. However, they may be satisfied nonetheless, especially if the access route has been used by the property owners for many years without any complications. Depending on the extent of the undocumented route, the number of other users, and the length of probable use, it may be possible to obtain forced blockage coverage under a TitlePLUS policy. Marketability coverage would not normally be provided to the purchaser, although it may be available for a mortgage lender. In contrast, it is also possible for your client's PIN to lack a together with in the legal description. Unfortunately, even if it was intended that the property contain a together with, you cannot just simply add it unless the servient PIN, being the roadway PIN, is specifically subject to your client's deeded right-of-way. If this is the case, then you can normally resolve the issue by preparing a notice under Section 71, followed by an application to amend the register. Being knowledgeable about title insurance and discussing the advantages when applicable is in compliance with Rule 3.2-9.4 of the Law Society of Ontario Rules of Professional Conduct. This rule states that a lawyer shall assess all reasonable options to assure title when advising a client about a real estate conveyance, and shall advise the client that title insurance is not mandatory and is not the only option available to protect the client's interests in a real estate transaction. There are further details provided in subsections 1 and 2, which again are included in your notes. Rule 3.2-9.5 states that a lawyer shall not receive any compensation, whether directly or indirectly, from a title insurer, agent, or intermediary for recommending a specific title insurance product to their client. Rule 3.2-9.6 states that a lawyer shall disclose to the client that no commission or fee is being furnished by any insurer, agent, or intermediary to the lawyer with respect to any title insurance coverage. Again, additional details are provided in subsection 1. An easement of necessity is a more complicated type of easement. In Ontario, this can arise when a property that is being purchased cannot be accessed except by crossing over the land that was retained by the seller. In this case, there may be an implied grant of easement to allow the purchaser access to their property by passing over the seller's land. The easement must be necessary in order to access or use the property, and the necessity is determined at the time of the grant. It is also important to note that if access without the easement of necessity is merely inconvenient, then the easement will not be implied. An easement of necessity can also arise in the opposite direction, where a seller requires an access easement over the land being sold. However, the seller will be subject to the test of strict necessity, which ensures that sellers are not permitted to derogate from the terms of their grant of land. An easement of necessity would only be found if it was necessary in order for the seller to use his or her property at the time of the grant. This was recently reviewed by the Ontario Court of Appeal in the Toronto Dominion Bank v. Wise case. In this case, the Wises owned a large parcel of land on Lake Manitowoc. Ben Wise passed away, and his wife was left as the sole owner. Ms. Wise severed the large parcel into 2 separate parts. Part 1 was conveyed to the Lipsons, and Part 2 was retained. The only access to Part 2 was by crossing over Inn and Tennis resort lands, which were on the other side of her property. The Inn and Tennis resort was subsequently sold, and there was never any easement retained either over the resort lands or over Part 1. Part 2 therefore became a water access only lot. Ms. Wise defaulted on her mortgage. The mortgagor wished to claim an easement of necessity over Part 1 and then sell the property. The court held that the strict test of necessity must be applied since this case involves a question of access to land retained by the seller. This test states that access must be required in order to use the property. Part 2 became a water access only lot when Ms. Wise sold Part 1 without retaining an easement. Water access, albeit inconvenient, does constitute access to the land, and therefore the land can be used. This does not constitute grounds for an easement of necessity. The purpose of these easements is to allow land to be used and not render it useless. However, these easements flow from the intentions of the parties. Ms. Wise did not retain an easement over Part 1 when she sold it, nor did she continue to cross over Part 1 after it was sold. There was no intention to retain an easement since, in fact, Ms. Wise gained access to her property by crossing over the inn and resort lands. The test applied by the application judge was not strict necessity, and therefore it was overturned. It is possible that a prescriptive easement may have been acquired by previous registered owners in cases where there is no registered right-of-way or easement. In these cases, the prescriptive easement must have been established prior to the property being converted to land titles. If the property is still in the registry system, then you will want to obtain a statutory declaration from the seller and cumulative declarations from previous sellers if they are available, in order to establish continuous, uninterrupted, and unimpeded access for at least 20 years. Caution is recommended when dealing with prescriptive easements, as the standards for establishing their existence is very high. The requirements have been recently reviewed by the Ontario Court of Appeal in English versus Para. This appeal involves a 14-foot strip of land, which is known as the shared driveway. The property line runs right down the middle of that strip of land, and there is a driveway on either side of the strip. There are garages located at the rear of both properties. There had been ongoing disputes about use and maintenance of this shared driveway, but things got worse when the defendants erected a fence down the center of the strip. There remained enough room for the defendants to access their garage. However, because of a retaining wall, there was not enough room for the plaintiffs to use their driveway. There was an agreement registered on title referring to the right-of-way. However, the agreement had expired. The Superior Court application judge found that the plaintiffs had acquired a prescriptive easement over the neighbor's property on the basis of lost modern grant. The judge found that the shared driveway had been used for the required period of time as of use and not by permission, and that this use was reasonably necessary to the enjoyment of their property. The appeals court judge considered that claims for establishing a prescriptive easement by lost modern grant burdened the servient owner's property without compensation. They discourage kindness and good neighborliness. They punish the kind and thoughtful and reward the aggressor. He also referenced that the use must be uninterrupted and unchallenged and cannot be by permission. The agreement between the owners, which was registered on title, acknowledged the existence of a right-of-way, which evidenced permission. Lastly, the onus to prove the necessity of the easement for enjoyment of the property lies squarely with the plaintiffs. A retaining wall was built, which caused the driveway to be too narrow without the easement. However, there was no evidence submitted to prove that the wall was necessary and not just decorative. The Ontario Court of Appeal judge therefore reversed the decision and found that the plaintiffs had not established a prescriptive easement for that shared driveway. The next section of my presentation will be on municipal road procedures. The majority of original road allowances that were opened prior to January 1st of 2003 had no bylaw passed to establish them. Instead, many of these roads were established through the expenditure of public funds or through Statute Labor. Since January 1st of 2003, when the Municipal Act came into effect, the only way to establish an original road allowance as a municipal road is by passing a bylaw. There is no actual requirement in the Municipal Act, however, to register that bylaw. In the 19th century, Canadians living outside of the big cities didn't have much in the way of municipal governments. This left them with a few problems to solve, such as the organization of schools and the maintenance of roads. In both Ontario as well as the Maritimes, a common way for resolving the issue of road maintenance was a form of conscription called Statute Labor. Those who owned property were expected to work on roads for a specific number of days, which was calculated in direct relation to the value of their farms. The idea was that those farmers that were more successful could afford to show up with a hired hand or two. For nearly 50 years on Prince Edward Island, from 1853 to 1901, the right to vote was based on performing statute labor. This system was widely accepted to the point that when the provincial government tried to abolish it in 1877, angry voters quickly threw them out. In the 20th century, statute labor fell into disuse, and PEI statute labor law was abolished in 1948. Here in Ontario, the Statute Labor Act still exists, and according to Ontario law, property owners could still be sent out to fix roads, shovels in hand. Some changes have been made to bring the legislation up to date. For instance, measurements have been updated to the metric system. However, dollar values haven't been updated to reflect inflation in decades. Owners of property worth less than $300 are liable to work for 1 day. Where the value is between $300 and $500, it's 2 days. Between $500 and $700, it's 3 days. Between $700 and $900, it's 4 days, and for every $300 above $900, it's 1 additional day. So based on these calculations, for anyone owning property worth more than $108,900, they would need to work 365 days a year. Of course, on the other hand, you could pay the township a fee instead of working, which hasn't been updated either, and it's still $3 a day. In all seriousness, if you need confirmation regarding whether or not an original road allowance has been opened, you may find it useful to check Google Maps, or you may try calling the municipality. Many cottage country municipal offices are very friendly, personable, and quite happy to help. The Municipal Act grants authority to municipalities to enter into these road access agreements, which are sometimes required in order for an individual to access their property. If a road access agreement exists, it would normally be registered on title. The terms of the agreement will often set out maintenance and upgrading responsibilities, and generally will not require that the road be upgraded to municipal standards. These roads are normally not open to the general public, although that restriction can be difficult to enforce. Usually there will be a private road sign posted. A typical scenario where you might see a road access agreement is where the alternative method of access is not passable due to environmental reasons. It is recommended that you investigate the terms of these agreements, and if the agreement is not permanent, you will want to ensure that the purchasers are aware that the agreement expires, and when that happens, they may be required to construct their own access road. Access should be investigated to determine whether the municipal road is traveled, graded, and plowed on a year-round basis. You will want to warn purchasers that at any time the municipality could pass a bylaw turning it into a seasonal road, which could significantly affect their ability to access the property. Often the maintenance of the road will depend on the number of residents that reside in the area on a year-round basis. The Road Access Act was passed in 1978 to prevent the arbitrary closing of private or access roads and to resolve disputes that occur when the property of one neighbor is landlocked and the only vehicle access to it is over a road located on private property owned by an adjacent landowner. This act does not create any rights to widen or alter the access road, nor does it create any maintenance obligations. The Road Access Act defines an access road as a private road on private land that serves as the only motor vehicle access route to one or more parcels of land. This act provides that the owner of the access road generally cannot close it without a court order. If, however, there is an alternate road access, then the act does allow the owner to close the road without that court order. In order to protect those who use access roads, the Act states that no one shall place or maintain a barrier or other obstacle across an access road that prevents access to one or more parcels of land, except when A, a judge has granted an application for a court order to close the road. B, the closure is made in accordance with an agreement in writing with the owners of the affected land. C, the closure is of a temporary nature for the purpose of repair or maintenance of the road. Or D, the closure is made for a single period of no greater than 24 hours in a year for the purpose of preventing the acquisition of prescriptive rights. If a road across private lands is an access road for use by motor vehicle, its use cannot be restricted to specific individuals or for particular purposes. Although an access road may be closed if there is an alternative viable access route, a decision with respect to road closures should not be made without much consideration as to who has a legal right to use the road and balancing those rights with the interests of those neighboring landowners whose property the road crosses. This particular act will certainly help to protect and preserve a property owner's access rights. However, I would bring your attention to the fact that the intention of this act is to resolve disputes that occur when the property is landlocked with no alternate road access. In Atkins versus Carter, the defendant was using an access road with permission that crossed an adjacent property owned by the plaintiffs in order to gain access from their property to a municipal road. There was, however, also a separate right-of-way that had been granted by the plaintiffs to the defendants, which was clearly intended to be used for road access. Due to the physical characteristics of the right-of-way, it would have been very costly to develop it as a road, and therefore the defendant continued to use the access road instead of the right-of-way. The plaintiff applied to the court for an order allowing him to close the access road. The onus is on the access seeker to prove that the Road Access Act applies by demonstrating that there is no alternate means of road access. Neither water access nor shore allowance access qualify as road access. The court has recognized that the legal box around the parcel may impede an alternate route, but impediments in the physical box are the problem of the access seeker. After contemplating the facts of this case, Justice Hennessy stated that the description of the right-of-way lands over the Atkins property describes most cottage roads in the Muskoka. That is to say, it is composed of hardwood forest mixed with rocky outcrops and swamps. This is not a description of an impossible route. This finding was consistent with the decision made in Monahan versus Stewart, where a township road connected to the southern limit of the defendant's land, and it was possible, albeit very expensive, to build an access road along the boundary of the defendant's land to his residence. As a result of this logic, it was determined that closure of the access road would not eliminate all road access to the property. After careful consideration in the Atkins versus Carter case, Justice Hennessy ultimately found that the permission was given to use the access road did not diminish the significance of the existence of the right-of-way. The defendant did not demonstrate that closing the access road would leave no alternate road access to their property. The court ultimately gave the defendant a 12-month period in which to continue to use the access road while they developed the right-of-way. In a more recent case, Brown versus Savage, one property owner crossed their neighbor's property via a laneway in order to access their property. Both parties recognized this laneway as an access road under the Road Access Act. The plaintiffs argue that there was no other means of vehicular access because the roadway they abut was on a steep slope with a sharp curve which would obstruct their view and cause safety concerns. The plaintiffs brought an application on 3 separate issues. The first argument is that they had acquired adverse possession of the laneway. Adverse possession requires an intention to exclude the owner from using the property for the requisite period of 10 years. The previous owner, Mr. Papineau, was not excluded from using the laneway. In fact, for some time, the neighbor on the other side of the plaintiffs also used the laneway to access their property. Therefore, adverse possession of the laneway could not be claimed. The second issue was a claim for a prescriptive easement. This claim also failed since unfettered access to the laneway had not been enjoyed for 20 years prior to the property being converted to land titles. This was evidenced by the fact that on one occasion, Mr. Papineau, who was the owner prior to the defendants, declined to allow the plaintiffs to pave the laneway, and on another occasion had required that the plaintiffs move their boat. The defendant asked for a closing order to stop the plaintiffs from using the laneway as she submitted that they were disrupting her use and enjoyment of her property. A civil engineer's report concluded that a parking pad, retaining walls, and stairs would provide adequate access for the plaintiffs to Northwoods Drive despite its incline and curve. Since alternate access refers to the legal box around the parcel of land and not the physical inconveniences, the court held that there was alternate road access available. The plaintiffs were given 1 year to construct their parking pad, retaining walls, and stairs, during which time the defendant was not to interfere with or block the use of the laneway for access to the plaintiff's property. These cases and many others demonstrate that the onus of invoking the Road Access Act lies squarely on the shoulders of the access seeker, who must demonstrate that there is no other alternate access available. Some cottage roads are located over Crown land, which is within the jurisdiction of the Ministry of Natural Resources. These roads were often originally used as logging or mining roads, and they may or may not be maintained by the municipality. Nonetheless, for all intents and purposes, these are municipal roads. It is important to satisfy yourself as to the level of maintenance of these roads. Occasionally, it is possible that this type of road is not maintained by the municipality, but instead either by the Crown or by private parties. The difficulty with making appropriate investigations when it comes to this type of access is that it is quite rare for the Ministry of Natural Resources to respond to any inquiries in writing regarding maintenance, although you may be able to get some assurances verbally. If the road is being maintained by the Crown, then there is always the chance that they may cease road maintenance if the logging or mining companies cease to use the road. Either way, there was always some level of risk that the municipal road may not be maintained on a regular basis, which could result in the municipal road becoming unpassable. There is some statutory protection for purchasers whose access crosses Crown land in Section 49 of the Public Lands Act. This section states that any person may exercise a public right of passage on a road other than a private forest road. The definition of a private forest road in the Public Lands Act would exclude most cottage access roads over Crown land. Therefore, the statutory protection would apply to most cottage owners. It is, however, difficult to provide any definitive assurances regarding this type of road. Therefore, it would be good practice once again to have an appropriate acknowledgement signed by your clients. Moving on to the next section, which is docks and boathouses. Waterfront properties, whether it's a home or a cottage, often come with docks and boathouses. It's not uncommon for these structures to have been built without a permit, since oftentimes municipalities have chosen not to exercise their jurisdiction on these matters. A recent court case, Glassbell v. Ontario, may change this approach. On Big Cedar Lake in North Kawartha, the Harts decided to build a large 1,000 square foot floating dock and then to erect a boathouse on that dock. Prior to construction, the Harts contacted the township's building department, and they were told that if the boathouse was to be constructed on the lake bed beyond the high water mark, that it was exclusively within the M&R's jurisdiction. The Harts then proceeded to contact the M&R to determine what permissions or permits were necessary. And again, they were told that the planned boathouse did not require either a work permit or an occupancy permit. With these confirmations, the Harts proceeded to construct their dock and boathouse. Once construction began, their neighbors, the Glassbells, were frustrated, especially since when they bought their property, their real estate agent told them that docks and boathouses were not permitted on Big Cedar Lake. In their frustration, the Glassbells inquired with the township as well as with the MNR, and despite the fact that site visits were ordered and completed, ultimately they were told that a permit was not necessary. Mr. Glassbell then decided to take the matter to court. Justice Perel presided and deliberated on 3 separate areas of legislation. First, zoning. The township took the position that the zoning bylaw did not apply, based on the fact that the structures were located beyond the high water mark, and in fact, that even the steel cable anchor was beyond the high water mark. Therefore, the entire structure was over Crown land, which is not within the jurisdiction of the township. Justice Perel found that the Harts did not enjoy Crown immunity, and the location of the anchor of the steel cable did not make any difference to their exposure to the zoning bylaw. In addition, and having regard to the public safety aspects of zoning and construction bylaws, zoning was deemed to be applicable. The Building Code Act was the second issue. The township took the position that the Building Code Act did not apply based on section 1.3.1.2, where the Act states that an application for a permit under section 8 of the Act to construct or demolish a building shall be made by the owner of the property on which the proposed construction or demolition is to take place. Justice Perel, for reasons similar to those about the application of the zoning bylaw, disagreed with the township's interpretation of the Act and found that this section should be interpreted to mean the owner of the property on which or for which the proposed construction or demolition is to take place. And the third issue, Public Lands Act. Section 26 of this Act makes it unlawful to take possession of public lands and to erect improvements without lawful authority. The Ministry of Natural Resources relied on its free use policy and took the position that the Harts had not taken possession of public land since the dock and boathouse were tethered to the shoreland but not actually erected on the lake bed. This interpretation of the policy then led the MNR to determine that there was no contravention of Section 26 of the Public Lands Act. Justice Perel found this interpretation to be fallacious and inconsistent with the intention of the legislation, and therefore found that an occupancy permit was required. This case has had a real impact on the way some municipalities now regulate the construction of docks and boathouses. After doing some research on how municipalities were reacting to this decision, I found that this case prompted a more coordinated effort amongst municipalities to approach the regulating of boathouse and dock construction in a more consistent manner. Prior to this ruling, some municipalities were requiring permits, and others were not regulating their construction at all. The judge in this case ruled that municipalities are required to enforce the Building Code Act with respect to construction of docks and boathouses. Zoning, however, is at the discretion of the municipality, which means that townships can choose to regulate the size, height, and look of boathouses and docks, and that they could choose not to allow them at all on certain lakes. Some townships have confirmed that to be safe, they are also requiring confirmation from the MNR showing that the government is fine with the structures being built. In an effort to include the general public on how the process is handled, there have been public meetings to gather input on the issue. Some have also expressed that they hope to see some discussion on the issue at a county level. I'd just like to take a second to speak to you as the consultant of TitlePLUS. TitlePLUS Title Insurance is our own all-Canadian bar-related title insurance program, and we are asking for your support. Our legal service coverage explicitly covers losses resulting from lawyers' negligence. This means that there are no circumstances in which a purchaser or lender protected by a TitlePLUS policy should be forced to sue their lawyer for a loss suffered in relation to the transaction where the lawyer was negligent at law. Most other title insurers do not cover all legal services provided by the lawyer. In the event of a claim, if a client has a TitlePLUS policy, he or she would simply submit a claim directly to LawPro under his or her TitlePLUS policy. The lawyer's E&O policy need not be engaged, and there would be no impact on the lawyer's deductible or premium in respect of the claim. We are continuously working to improve the TitlePLUS program, and we hope that you will show your support by recommending our products to your real estate clients. For those of you who have continued to support us, we want to say thank you for your loyalty, and we promise to continue to serve you and your clients to the very best of our ability. So that concludes the presentation. I'm going to open up to questions, and I see that there may be a few here that have come in. Oh, sorry, these are not questions. Yes.
I had a question about the colonization road.
Yes.
I've never seen any. So, have you ever come across it? Like you said that it doesn't show up on the parcel, the PIN. So, how would it show up? In a road law search?
Okay, so I'm just going to repeat the question for everybody out there. The question is about colonization roads. We're asking if there would be any evidence of a colonization road anywhere, how would you find it, and what investigations would you make? So the case that I found, there really was absolutely no evidence about that colonization road. The best suggestion that I can give you is to make inquiries with the seller, because if there have been any difficulties with the land, then they would be obliged, of course, to explain that to you. There really is nothing else that you can do. There are no real investigations because these things are just not showing on PIN maps. Some maps which are very old might show them, but of course these types of investigations are difficult to do. Okay, so this is a question that came in online. The question is, I've seen a case where the municipality was maintaining a road, but they would not admit it was a municipal road. It may have been that the snowplow did the work even though it wasn't required. What would happen if they later stopped maintaining it? So this is one of those scenarios where we're trying to find out if the road is being maintained by the municipality or not. You can contact the municipality to see if it's on their schedule. These, for instance, this was a case where the snowplow was going through. They do have records to tell you about the routes for these snow plows, and if that plow is shown on the municipal records as having a route, then it is being maintained municipally. If it's not showing on their records, then that's a case where it's likely not actually being maintained on a regular basis by the municipality. So what would happen if they later stop maintaining it? That would be an issue. So this is something that you want to explain to your clients could come up after they take possession of the property. You cannot guarantee them that the road will continuously be maintained by the municipality unless you have confirmation that it is a municipal road. Okay, I have another one here. This one's a bit more difficult to read. Regarding throwing a wrench in the amount that has already been paid in property taxes for these affected properties, would this justify I think this says disputing historical taxes paid by the clients with the unopened shoreline road allowance, or merely justify future taxes going up once it is purchased? Is this a reason not to purchase the shoreline road allowance, as it may increase taxes possibly? So the investigations that I did were actually pointing out the fact that waterfront property owners do often pay higher property taxes because those properties have been classified as waterfront. But where you have that shoreline road allowance running in between, technically they're not waterfront properties. So in this scenario, he's asking, would this be a reason not to purchase that shoreline road allowance? But from the research that I did and from what I saw, it's very rare to see that a property that does not own that shoreline road allowance in between it and the water is not classified as waterfront. Normally they are, and they have already been paying higher taxes, so I wouldn't necessarily see that as a reason not to buy that shoreline road allowance. Any other questions? Yes.
When you deal with a cottage or rural property using a standard agreement of purchase and sale, it doesn't seem to me that there's very much ability of the lawyer to raise any objections or to get out of the transaction for the client. So this to me is advice that I shouldn't be dealing with these properties at all. Possibly see how I could protect myself if I didn't know the area, if the client didn't know it, and if I didn't have a chance to review the agreement of purchase and sale before they signed it. And even if I did have a chance, I likely wouldn't be able to adequately protect myself.
That's right. We're really, with the agreement of purchase and sale, we're really relying on these real estate agents that are practicing in areas that are considered more rural and that may have access issues, although sometimes it is a problem with urban properties as well. But yes, you want to hope that the real estate agent includes some sort of a condition so that you can investigate access and make sure that it's proper before the deal firms up. But you're right, there's not any other protections in the agreement of purchase and sale.
I mean, when I get a cottage now or a farm, I refer it to a local law firm that specializes in dealing with these types of properties. I wouldn't even attempt to act on it.
Sometimes that is the best choice because there certainly are a lot of issues to investigate. Yeah. Okay, so I think that wraps up this presentation. Thank you very much.